Mr Speaker.
Carmel Sepuloni.
Mr Speaker, I just want to start by speaking to the point that was raised by the New Zealand First MP, Derek Ball, and that was with regards to a briefing that the Minister of Social Development held for Labour MPs at 1 o'clock today on this bill. Actually, Mr Speaker, we thought that it was a briefing for all parties outside of the National Party, so we're surprised to attend and find out that it was just myself, Nanaia Mahuta and also Jacinda Ardern. So we were unaware that that briefing was just for Labour MPs, and actually we do and would expect that a briefing of that nature would be given to all political parties so that when we come to debate it, particularly because this has been pushed through rather quickly, that we are all on the same page with regards to background information. So we're disappointed as well that that briefing, that opportunity for a briefing wasn't extended to other political parties. Mr Speaker, I want to start on this bill with the parts that we do support before getting into the area, the major area that we don't support. Labour has, Mr Speaker, as this House knows, for a long time been calling for the age of care and protection as well as youth justice to be raised to include 17-year-olds in alignment with the UN Conventions on the Rights of the Child. So we are pleased to see that this has been considered and incorporated within the SIF's reforms. It is also positive in this bill to see the government again taking into account the recommendations of the UN Convention on the Rights of the Child by enshrining the well-being of children as a central focus of the new ministry, Oranga Tamariki. However, Mr Speaker, despite parts of the bill proposing a prioritisation of the interests of the child in state care, it goes against this overall concept by removing the emphasis on kinship care. At the moment, priority is given to placing a child with a member of their family or wider hapu, and if that's not possible, then to someone who has the same tribal, racial or cultural background as the child. However, this bill removes that whānau first preference, and we heard one of the New Zealand First MPs saying that we were in some sort of la-la land for thinking that that could possibly work or that was the right thing to do. Mr Speaker, there is international evidence to show that it is the right thing to do. It should be enshrined in our legislation. The problem isn't with it being in legislation. The problem is the way in which it has been enacted in practice. And so the safety of the child, yes, should be the primary concern. So if you find a whānau member that is able to look after the child, firstly, you are going to assess whether or not that whānau member is then a safe person to look after the child. And if that's not happening, then we have an issue with practice and the way in which it is enacted. It is not about putting that in the legislation. So this removal of Clause 13F, the provision around kinship care, could significantly weaken the role of Māori in the care and protection of children. So while there are some positive aspects to this bill, we cannot support it due to the overwhelming concerns we have in the proposal about the lack of incorporation of whānau, iwi and hapu solutions in the care of children. The disregard for Clause 13F goes against evidence both locally and internationally. We know that the best solutions for children include early intervention and an incorporation of iwi throughout the process. This is also true on an international level, as I said, with a prioritisation of a children's cultural heritage being instrumental to their care. Mr Speaker, the new ministry must take into account the importance of culture in a child's life, especially to their identity and sense of belonging. As Green Party MP Jan Logie said when questioning the minister last week, quote, "For tamariki Māori, their well-being is inextricably linked to their well-being of their whānau and hapu," end quote. There was also a strong need for a sense of belonging found amongst children in state care. This year's State of Care report from the Office of the Children's Commissioner stated that clearly. And so, even through the conversations that I've had with national MPs, we all agree safety, stability, identity, and the other issue, of course, being with family whānau, Mr Speaker, or siblings actually, as has come up in conversations. The report found that children and young people are already not given sufficient opportunities to build their sense of identity in the current process for children in state care. This can only get worse with the removal of the whānau first clause. Mr Speaker, we are concerned that there has been a lack of consultation with respect to this bill. Around 60% of children in state care are Māori, as has been pointed out by previous speakers, yet there was not enough discussion with Māori groups and organisations that have experience in the care and protection of children. The Māori Women's Welfare League have even raised concerns that the changes proposed in this bill could be in breach of the Treaty of Waitangi, and did request that the bill not be put forward until they had been properly consulted. Mr. Speaker, looking at the ethnic identity of children that are in state care, I saw, even with my own Pacific people, Pacific children make up the third highest ethnicity of children in state care, Mr. Speaker, and with 407 as of June 2016. In 2010, the government's Pacific Action Plan specified an aim to keep Pacific children and young people well cared for as part of a loving whānau. This was an acknowledgement of the different cultural upbringing and the importance and presence of wider family for Pacific families. Yet the removal of the kinship clause is far removed from this multicultural focus. There has also been a distinct lack of consideration given to Pacific groups and experts. The hurried nature of this current bill has meant little time for key Pacific organisations to consider these changes and provide input. It's been virtually impossible to find comment because it's gone through so quickly and people have had no time to consider the consequences of what this bill is putting forward. This bill also proposes a requirement to develop strategic partnerships with iwi and Māori organisations. However, this cannot be possible without the kinship care clause. While this bill proposes it will be more child-centred, it fails to address the key issue of what the current SIFS legislation is not and where the system is failing. As is addressed in the Departmental Disclosure Statement, there is currently no cause given for the need to change legislation. Without acknowledging what the current issues are, it cannot be possible for this bill to improve the situation. And the example I want to give is that the Minister has argued that the current legislation has been employed in a way that kin care is given as the only option, whether it is the safest and best option or not. However, in this case, it is not the legislation that is the problem, but as I said before, the implementation and the practice at a service level. This is where the change needs to occur, rather than the removal of a whānau-first approach. Mr. Speaker, the proposal to make this bill child-centred raises the issue of why the government won't commit to making other key sectors that have an effect on a child's well-being child-centred. Areas such as health, social housing and social development are all oriented around policies and laws that do not put the needs of the child first. For the plight of children and hardship to be addressed, there needs to be a holistic and government-wide commitment to putting children at the centre, not just in this one area, but across the board. So it's unfortunate that the Minister has shown an unwillingness to do this, even across her own portfolios, having dismissed my proposed amendment to the principles of the Social Security Act, which would have included a new principle that, quote, would have said primary consideration is to be given to the welfare and best interests of any child or children who may be directly or indirectly affected by the exercise of that duty or function, end quote. Why would any government not want that to be an underlying principle of our Social Security Act, Mr. Speaker? So, as I said, Mr. Speaker, we have some serious concerns. The final concern I want to share is with respect to data. The Privacy Commissioner has also raised several concerns about this. Firstly, the issue is not confined to this bill, but is slowly being implemented across the social development sector. Concerns have already been raised from those who will be affected about the government's current inability to deal with the data, the increased level of surveillance for those seeking help, and a potential reluctance from people in sharing information knowing it will be held by the government. The Commissioner highlighted the unintended consequences of this data sharing clause, given that there is not currently a fully designed operating model for Oranga Tamariki, and there has not been consultation with those who could be affected. The level of data sharing proposed could also risk the trust and rapport between case managers and their clients, potentially impacting the level of support given. This proposed data sharing, Mr. Speaker, is a part of the government's investment approach, which frames people and children as potential liabilities. The data collection in itself will encroach on the privacy of individuals and is akin to selective surveillance. On top of that, the data will be used to target those who are considered to be fiscal drains, We know that the government believes our young people are already pretty damned hopeless. Thank you to the Prime Minister of New Zealand for saying that, meaning they are not interested in investing in our young people, but rather viewing them as financial risks. And what a way to view our young people. And it's really hard to reconcile those kinds of statements with the statements that come out of that minister saying that it should be about being child-centred, when in fact it doesn't feel that way at all, Mr. Speaker. We will not be supporting this bill.
The member's time has expired.